So, now we go from the cutting edge back to 1891, Madrid system in 1925. Sorry, but it's also an important topic. As was mentioned, one of the titles, or in the description, I mentioned that these two systems, the Madrid system for the international registration of farms, and the Hague system for the international registration of industrial designs, embody a timeless concept. In a way, it's a timeless concept whose time has come. And I'll hopefully explain that in a little more detail as I go on. The timeless concept is no secret. It's the concept of centralization. The centralized acquisition, maintenance, and management of trademarks, Madrid system, and industrial designs, the Hague, by filing a single international application for a single international registration in which one or more contracting parties are designated. It allows right holders to target national, regional, or global markets with respect to particular goods and services in the case of the Madrid system, or just goods in the case of the Hague designs. It's cost-effective and efficient, and creates opportunities that would otherwise exist for any enterprise with a limited legal budget. Now, I say limited legal budget because what comes to mind is a company that uses this system a lot, Microsoft. And Russ Pangborn, who actually we interviewed, and you can see his interview on our website, mentions how he was under tremendous pressure to cut costs. So he was one of the first people to try the Madrid system when it entered into force in the United States. So it's not necessarily small companies that feel the bite of excess costs. One of the results of simplification, of this type of centralization is simplification. As you know, to acquire national rights, you file directly in the offices of each country. Here, Office A, B, and C for the respective territories. Using these systems, the centralized filing systems, you can file a single application that's routed through the International Bureau of the World Intellectual Property Organization, and then forwarded on to countries of your choice. The immediate practical effect of this simplification is that you only have to do one thing, or before you had to do many. And I'm talking about the offices that you file with, the languages you use, currencies, the number of registrations, renewals, and modifications. And the last item, which is sort of a feature of the systems that is controversial, as a matter of law, and I emphasize as a matter of law, not as a practical matter. You don't need a foreign attorney or agent at the time of filing. Under these systems, the first time you need a foreign attorney is if a refusal is issued. But again, that's a matter of law, not a practical matter. You might well want to consult your attorney ahead of time. So as such, these two systems are an important part of the legal framework that facilitates the natural growth, mainly via export, of a small, medium, or large enterprise into a truly global entity. While perhaps it's just a minor component of the infrastructure necessary to facilitate economic development, these two systems have nonetheless a worth that can equal or exceed more tangible capital projects. They are low cost and flexible means for securing the rights that either are or can become the legal cornerstones of grants. This concept of centralization, and again as applied in these two treaties, fits the business models of companies, so we're told by our users, that export, especially with respect to cost savings. There certainly are limitations to the system, and that's not surprising given what it tries to achieve. And there are even disadvantages. But these risks are manageable, and that a knowledgeable and experienced attorney or practitioner can anticipate and deal with it. But none of this is new. As I mentioned earlier, the Madrid Agreement, which is one of the treaties of the Madrid system, was concluded in 1891. The Hague Agreement was concluded in 1925. In fact, when I looked at a history of the Madrid system, I came across this passage by David Tatum of the UK. He wrote, referring to the conclusion of the Madrid Agreement back in the 1890s. At this time, towards the end of the 19th century, at the adoption of the Madrid Agreement, the world was just starting to draw breath from the heady progress made during the second phase of the Industrial Revolution. One of the principal manifestos of this had been the creation of railway networks. These networks made it possible for trade and commerce to move rapidly, not just within the country, but across national frontiers, and not just into traditional markets in neighboring countries, but farther afield. Could it be, based on what David has said and what we all know happens today, that the more things change, the more they stay the same? But to bring Tadham's observations up to date, the difference now is access. More recent industrial revolutions, such as improvements in transportation, like containerized shipping, advances in technology, such as telecommunications, computing, and the internet, have lowering barriers to trade, have given more access to smaller companies. These opportunities that Tadham refers to are now open to even the smallest companies to a much greater extent than even before. SMEs can now begin operating as global entities early in their life. Some commentators have even gone so far as to claim that every company, regardless of size, must become a global corporation in order to achieve its potential, or in many instances, in order to survive. Maybe at this point in time, this is a bit of an overstatement, but it seems to be the trend. And these numbers that I've brought up on the screen sort of reflect that. These show the portfolios, the number of international registrations and portfolios that individual owners hold international registrations and portfolios. And in both of them, in the Madrid and the Hague systems, what all those numbers mean is around 80% of the holders have portfolios consisting of one or two international registrations. And when you go through our databases to see who these holders are, you realize that the vast majority of the users of the systems are smaller companies. And this is obviously a relatively recent development, well, relatively recent, I think, in a couple of decades, but certainly since the beginning of the systems. So, I don't know if I call them conclusions, but there are four propositions that I might say, or three propositions and one comment that I might say about these systems. One, they're strongly aligned with the user's needs, as we're told by many times that we have contact with them. It enables integration and deployment of IP within a business strategy. There's another interview up on our website with Owen Malone from Treasury Wine Estates, who makes this point time and time again in his presentations. And notwithstanding its limitations, and it does have limitations, the design is basically sound. Common is that for the future, there's some changes that need to be made, and most involve consistency and reliability, and better and more timely dissemination of information. I don't want to take up too much time because we're running short, so I just wanted to go over a little bit of the aspects of the international legal framework. And they move through these slides pretty quickly. But I'll be here today, tomorrow, if anyone wants to stop, talk to me in detail about any aspect of these treaties, more than happy to do so. But I just want to give you a flavor for it now. Basically, there are three aspects to this international system. There are the treaties, which form, obviously, the basis for the system. And then there's a one set of common regulations for all treaties in the system, and one set of administration instructions that manage all the different interactions or iterations that might occur, depending upon to which treaties a given contracting party is party, one or the other or both, or formerly in the Hague system there were three, but now we're down to two again. And then the third aspect is the national laws and regulations which actually implement the system as a substantive law at the national level. Just briefly, the Madrid system has two principal treaties, the agreement and the protocol. The protocol is the more modern treaty, 1989. That I would just say is the treaty of the future. The Madrid agreement is being phased out slowly in a number of ways. The protocol is the treaty of the future. The Hague system has the Hague agreement with several acts. It's a little different structure, but it's similar in that the Geneva Act, the 1990 Act, is the more modern treaty. and it's the one that will be used in the future. And again, the Hague Act from 1960 is slowly being phased out. Now, the reason these new acts, both in the Madrid and Hague systems, were adopted were to expand geographically the systems. Obviously, they both started as Eurocentric systems, but are now aspiring to be truly global via the treaties. They're closed systems in two ways. One, you have to be entitled to file. You, as a user, or holder, owner of a trademark right or a design right, have to have a connection with the country. And there are several legal standards: establishment, domicile, residence, nationality. The main point to remember is you actually have to prove that you, or have to establish that you do have a connection. Obviously, if a company is in a country and they're filing through that country, it's a pretty straightforward determination. But it can get somewhat questionable at times. And secondly, the other way it's closed is that when you get an extension of protection, when you designate contracting parties, you can only designate contracting parties. You can't take countries that have not signed this treaty. So it's very different from the concept of community trademark. Regarding the acquisition of an international registration, you would file an international application. Generally, in both systems, you can file indirectly. And by that I mean through your own country's office before it gets to the International Bureau. In the Madrid system, there's a prerequisite. You have to have a prior national right. It's called a basic mark. That's different from the Hague system, where you do not. You can just file a Hague application for the first time. After I'll call it the Office of Contracting Party of Entitlement, examines to a limited extent in each case the international application is forwarded to the International Bureau. However, with the Hague system, since there is no requirement for a pre-existing national right, it is possible to file directly with the International Bureau. And thereupon, the International Bureau will forward the resulting international registration to the office of each designated contracting party. Although it's called a registration, at this point in time it has the effect of an application and is examined, and we'll see the duties here. So the international application goes to the Office of the Contracting Party of Entitlement, your home office. Under Madrid, this is a more complicated certification process that has to be undertaken to match the particulars of the international application with those of the basic mark. With the Hague system, there's something called a security clearance, which depends on national law. And it was written in specifically for the United States and anticipating U.S. joining because of their export licensing laws. That basically the application would go to the USPTO first. They would determine if there's any important technology that they don't want to disclose abroad. And if that's okay, I think it's passed on. So that option was built in, especially to the UNIT. When the International Bureau gets an application, it does a formalities examination only. Records in the International Register, issues a certificate of international registration, publishes in both cases, and notifies actually in Madrid. At that point, the Office of a Designated Contracting Party that receives that information, differently depending upon the treaty involved, there are two things that it can do. It can either do nothing, issue no refusal, in which case, after a certain period of time, the designation would have effect as a national right, or it can issue a refusal, in which case the whole process is switches to the national office, and the holder communicates directly with the national office. Just to run through a few general characteristics of the international application regarding reproduction. In Madrid, it's one mark per international class. In Hague, the international application can have up to 100 designs. Very cost-effective. Fees, both the Madrid and Hague have something called a basic fee. The Hague has a publication fee. These are administrative fees paid to WIPO. And then the designation fees are the fees that are due to each country that you might designate in the international application. Priority, you can claim priority under both systems. In Madrid, the most common situation is where you file a basic application, a basic mark in your home country, then an international application, and the international application claims priority back to that national right. The Hague actually can be a first filing itself and be used to make a claim of priority elsewhere. Again, because there's no pre-existing national right. Publication, Madrid, it's almost immediately after recording. In Hague, the Geneva Act takes 6 months. It was decided it would be the best time, but there's a possibility of deferring up to 30 months before publication if you want. With regard to maintenance and management, I mean, this is one of the main things that makes these treaties different from something like, let's say, the ECT. The international registration, or this concept of an international registration, can also be used to subsequently renew all your individual national rights, you bundle, and maintain them. And by that I mean things like change of ownership, change of change of name, change of address, limitations. All can be done centrally, one filing, and then distributed to all the countries in which the international registration has effect. Geographic expansion of the system. I just wanted to run through this for a few seconds. And keep in mind, when you look at these two maps, obviously the Madrid system expanded is bigger in its geographic scope than the Hague system. But the Madrid Protocol became operational in '96, and the Geneva Act, the most recent act of the Hague Agreement, became operational in 2004. So we're seeing the Hague system pretty much follow the pattern of the Madrid system before it. At present, there are 88 contracting parties to the Madrid Protocol. And the most recent, which actually enters into force, I put 13th February in the upper right-hand corner of the slide. It should be the 19th of February. Mexico joined the Madrid Protocol. And the system, that was a big step. It was Latin America. It was a hard nut to crack for the Madrid system. Colombia went first, which dealt with a lot of the legal issues or objections that are raised commonly throughout South America. It passed executive, judicial, legislative tests. They joined, and then Mexico joined, which is a big economic boost for the system. And especially for U.S. users, since Mexico, I think after Canada, is their second largest trading partner. So I think that we'll see it move into South America. Maybe not quickly, but it's clearly on its way. Again, there are actually 89 members of the Madrid Union, because there is still one country, Algeria, that is only party to the agreement. We're working on that, and should they join this year, then basically the system would be a Madrid Protocol system only. And we're looking forward to that. And there might even be talk of somehow freezing or neutralizing the agreement to move it out of the picture altogether. Geneva Act, much smaller, has 45 contracting parties, including the EU with its 27 states and WIPO with its 16. So it amounts to 70 states are covered. Because if an intergovernmental organization is party to this treaty, each of its states does not have to be party. The territory as a whole is eligible for protection and participating. 45 members of the Geneva Act, 15 of the Hague Act. And the London Act, which used to be the third act, was recently frozen, so it can no longer be used, although the registrations created under that will continue to be enforced until they run their course. Continued growth, we certainly expected in two ways: geographic expansion. Certainly the system becomes more attractive as more trading partners join. I mentioned the fact that Mexico joined, certainly attractive to the United States, but it's also a real incentive for a country like Canada to join. There have been various reasons why Canada hasn't joined the system, but we think that this might give a little push there. I don't think it'll happen quickly because there are a lot of things that need to change in their law, but I think, again, that accession was a very important one in terms of moving things along. And I've tried to keep this short, brief, so I'm going to stop here because our esteemed colleague here, I'm sure, has a lot to say. Again, I'll be happy to take any questions during the question period, but more importantly, if you really want to talk about something in detail, I'll be around later today, tomorrow as well. Thank you very much.